Today, we're talking about social media posts while you're involved in a personal injury lawsuit. There are some important things that you need to be aware of if you're involved in a personal injury lawsuit, and some things that can definitely affect the outcome if you're not careful. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people get the compensation that they deserve for their injuries. Today, we're talking about this important topic, how your social media posts can impact your personal injury case. The reality is anything you say or post online can be used against you in a court of law with limits. And we're going to talk about those limits. While we live in a digital age where sharing moments of our lives on social media is second nature, this can affect your lawsuit. So you do need to be careful, whether it's posting pictures of a night out, sharing vacation snapshots, or updating your status. These posts can be viewed by a wide audience, and they can last a long time in terms of even when you delete them. So what happens when you're involved in a personal injury lawsuit? Despite taking steps to ensure that your information remains private, your privacy does become vulnerable once you're embroiled in a civil lawsuit. A fundamental rule of law is that all relevant evidence is generally admissible in a court case unless there are good reasons to exclude it. This means that your social media posts can potentially be used as evidence against you. It's not hard to see how some posts could be relevant. So say that you file a personal injury lawsuit where you say that you're badly injured and you can't move as usual. And then social media posts surface showing you dancing at a nightclub or hiking up a mountain. So this can seriously undermine your case, and these posts likely will be relevant because they go to the issue of how injured you are and also to your credibility. Under Rule 30 of the Rules of Civil Procedure, every litigant must disclose and produce every document relevant in the case, and this is in relation to the discovery portion of your lawsuit. This includes electronic data and information such as social media posts. In fact, the courts have ruled that even private social media posts may need to be disclosed if they're relevant. Courts have dealt with this issue in various cases. It is a pretty common case or an issue that arises in cases. In Leduc and Roman, the court held that relevant public postings are producible. Similarly, in a case called Papa Michaelopoulos and Greenwood, a plaintiff had to produce photos from a private Facebook profile because the public profile already depicted activities inconsistent with his injury claim. In a 2023 case, Mohammed Andjuski, the Ontario Superior Court of Justice ordered the plaintiff, who was involved in a motor vehicle accident, to provide a list of all photographs in her possession, including those on her private social media accounts that are relevant to the case. The court emphasized that determining relevance is straightforward and requires a very low threshold. The court inferred that the public profile had material that was relevant, therefore the private profile likely contained similarly relevant content. These cases highlight that if a public social media profile provides enough evidence, a court may order the disclosure of private posts. This means that your social media activity can become a critical point in your lawsuit, so it's definitely something to keep in mind. It's not always a given that the court will order that your private social media accounts are disclosed. In one case called Murpaugh and Hyde, the court found that there was not enough evidence on the public profile to justify access to private posts. This shows that courts can sometimes protect private social media accounts if there is no substantial reason to believe that the private one would contain relevant information. As seen in Asakov and Schwarzenberg, if your posts show activities inconsistent with your injury claims, courts can rule that these posts must be disclosed regardless of privacy concerns. The judge in this case concluded that the plaintiff's social media activity was relevant to the litigation, and this relevance outweighed the privacy arguments brought by the plaintiff's lawyer. So the lesson is clear. If you have been injured and you're pursuing a lawsuit, be cautious about what you post online. Anything that you have posted may be scrutinized and may be used against you. If you've been injured and wish to pursue a personal injury claim, it is crucial to consult a personal injury lawyer who can guide you through the legal process and give you advice about your particular situation. If you have any further questions, I would be happy to have a chat. Leave me a comment below or send me a message. You can contact me at the information in the video.